I'm Vincent Rosillo, and I'm a partner in the law firm of Final and Andaman. And I'm here today with Christina Dulé, who works out of our New Jersey office. She specializes in personal injury and workers' compensation in New Jersey. We're going to talk today about some basic questions that we get regarding workplace accidents. Welcome, Christina.
Hi, thank you for having me. I'm happy to be here.
Christina, we get many questions about workers' compensation, so I'd like to take some time to answer some basic questions. The primary question that we usually get is, can I sue my employer for a workplace accident? Is a workers' compensation case a lawsuit?
Sure. So no, workers' compensation is not a lawsuit at all. I usually like to look at it as more of an administrative process. Generally, the law prevents an injured worker from suing their employer for a workplace accident. And so therefore, it's more of an administrative process.
Does that mean that an injured worker can't sue anyone for the accident that occurred?
They can sue somebody for the negligent actions that third party caused. And the common example that I always like to give to my clients is the case of a sanitation worker that's going about his garbage disposal duties, and he then gets hit by a driver in a car. In that case, the person driving that car, that employee has a right to sue for that driver for any negligent actions caused, and he can therefore file a lawsuit in that sense.
So let's talk about fault, because in a negligence setting, fault is a key issue. But what about in a workers' compensation case? Can someone file a workers' compensation claim even if it's their fault?
Sure. So in a workers' compensation case, that's the whole idea of the workers' compensation statute. And I always like to tell my clients that in the workers' compensation statute, they take out the idea of fault, and therefore it becomes a no-fault process where they're not looking to blame the employer or the employee for any fault that they contributed to the accident. So in that sense, then, there's the two main things that they're really entitled to under the workers' compensation statute, and that would be the medical treatment that they're entitled to, along with any temporary disability benefits, which are essentially what I like to look at it as wage replacement for the time that they're out trying to rehabilitate and get that medical treatment.
We can talk more about that later, but let's talk about notice, because people don't realize often that they have to notify their job about the accident. So is that a requirement? And what is the notice requirement?
Sure, it definitely is a requirement prior to filing a case in workers' compensation courts. So the notice requirements here are you have 30 days from the date of the accident to notify your employer. And in the case of an occupational disease, you have 2 years from the date you knew or should have known that the condition was work-related.
So is notice enough? I mean, do I have to actually file a claim with the state of New Jersey?
Right. So before filing a claim, you have to give notice to the employer, and that culminates in an incident report. But from there, if you're going to continue on and file a case against the employer, you then have to file, you then have time requirements. Those time requirements are, in the case of an accident, you have 2 years from the date of the accident, or in the case of an occupational disease, you have 2 years from the date that you knew or should have known that the condition was work-related.
So you made the reference to occupational disease. Can you describe the difference between an occupational disease and an accident? Maybe give us an example of an occupational disease.
An example would be, let's say an office worker gets carpal tunnel syndrome from typing all day. So in that sense, an occupational disease is something that happens over the course of time that arises out of and in the course of employment. An accident is an identifiable event that happens in the course of employment. There really is a broad definition of in the course of employment as well as accident. So even though you don't need an attorney to pursue a claim, it's definitely in your best interest to consult with an attorney, especially since there is never a consultation fee and the fee is only awarded at the resolution of the case.
So I think you may have mentioned that an occupational disease happens over the course of time. So would carpal tunnel syndrome, where you're constantly typing on a computer keyboard as part of your job description, would that be considered an occupational disease?
Exactly. That is definitely considered an occupational disease since there's no identifiable event, such as an accident. There's an identifiable specific date of that event.
Okay. Now, earlier you mentioned weekly benefits. How much is someone entitled to receive?
Sure. So somebody is entitled to receive in a workers' compensation case, they're entitled to receive 70% of the average weekly wage rate, and that's capped at $945. And currently that's the amount for 2020.
Okay, so let's shift gears a little bit. Let's say someone had an accident but did not see a workers' compensation doctor. Are they precluded from filing a claim?
No, you can still file a claim. It's just that you have to be seen by an authorized workers' comp doctor. In the state of New Jersey, the employer always directs the treatment. So in your scenario where the injured employee went to the ER first, which is it's common, it happens, but they then have to seek authorized care through the insurance carrier.
The monetary benefits that you alluded to earlier, are they taxable?
No, the workers' comp benefits are tax-free.
Is there a waiting period before someone can actually collect this weekly money?
Sure, there is a 7-day waiting period to collect the money. So essentially, it doesn't have to be consecutive. It can certainly be cumulative. And you definitely shouldn't use your sick time or vacation time. So that's why it's important to keep in touch with the carrier to be able to determine that time frame so that the 7-day kicks in, you get your temporary benefits.
So someone's entitled to a weekly temporary benefit, and they're also entitled to medical care. Is that medical care 100%? Are there any co-pays, deductibles? How long would that medical care last?
Sure, the medical treatment is always at 100%. So there's never any co-pays that the employee has to pay out. And that's what the whole design of this workers' compensation scheme is designed for, so that the coverage is always at 100%.
Is there an award for any kind of permanent loss of use?
There is. There is an award, and that usually arises at the end of the case where that's determined. And that's determined based on, however, it depends on the permanency of the loss of use or the loss of function. And I always like to explain that in the case of, let's say somebody breaks their arm, then as with any broken appendage, let's say, it never really recovers at 100%. So whatever that percentage as determined by a workers' comp doctor or rather an expert would determine that percentage relates to some kind of quantifiable amount that relates to some award.
What about death benefits? Is it possible that someone could collect death benefits if a worker should die in the course of their employment?
Sure, yes, it is possible that the family of the worker gets to collect benefits, provided that they had dependents.
We get questions sometimes from people who slip and fall in the company's parking lot. The employer doesn't believe that it happened. There are no witnesses. The employer refuses to notify his insurance company. Can an injured worker still file a claim if the employer doesn't want to proceed with it and file the claim?
Yes, so even if the employer doesn't believe that the injury occurred, you should definitely seek an attorney to assess that, because you should definitely that is worth filing a claim, but an attorney can definitely assess whether there are any issues or hurdles as to filing that claim, and if there were any notice requirements that weren't abided by in order to file that workers' compensation claim.
We get questions sometimes regarding the Family Medical Leave Act, and I know the Family Medical Leave Act, FMLA, is a federal law, and New Jersey workers' comp is a state law. But can an employer require an injured worker to use their FMLA time while out on a workers' compensation case?
Yes, they can require an employee to use their FMLA time.
So it sounds like workers' compensation is really a fact-specific area of the law. And I would think that it's important to consult with an attorney regarding all types of these scenarios. Is that correct?
Sure, yes, that is definitely correct, and it's entirely fact specific. That's why it's important to consult with an attorney, because you shouldn't make that decision without speaking to an expert. And although workers' comp is fact specific and it's a no fault system, it's still somewhat of an adversarial process. So the employer always has representation, so you should definitely have representation as well that can advocate for your best interests.
That's a good point. And thanks for taking the time today to discuss the basic issues of New Jersey workers' compensation. If someone has a question regarding a specific case or a specific incident, they should feel free to call us at 1-800-522-9001 or review our website at www.foalaw.com. Thanks again, Christina.
Thank you for having me.